I'm going to wait just a minute for our vice chair to get back. I've got a terrible time crunch today. I had anticipated we would be off the floor much faster and starting this at about noon. I have to be back in Athens by 3:30, and the vice chairman's going to take over in my absence after we get rolling here. But I wanted to hear some things from you, Joe, that we had talked about, so let me just wait one more minute, then we'll get started.
Balance it out.
Committee. And we have three potential witnesses today. I'm going to start with Mr. Joe Mulholland, who is Chairman, President, I don't know your term, of the District Attorneys Association. If you would, please just introduce yourself, and then we got a few questions for you.
Absolutely, sir. Thank you for having me. I'm Joe Mulholland. I'm the District Attorney for the South Georgia Circuit. I have served in that capacity since 2004, so this is my 22nd year. This year I serve as the President of the District Attorneys Association for the state of Georgia.
We have heard some testimony, particularly from Fonnie Willis, about the funding of district attorneys and her concerns that we are inadequately funding prosecutors in the state. I'd like for you to share with us the details of how district attorneys are paid, what comes from the state of Georgia, what comes from local supplements. If you can just sort of give us the overview, what the pay rate is from the state and what the number of assistant DAs we fund for each circuit.
Sure. So statutorily, I believe, and the numbers are, is that you basically get an assistant DA per judge. So in my circuit, I've got 3 judges. So I get 1 assistant DA per judge. I also get a chief assistant district attorney. So for that, that's 4 for me. Then we have a drug prosecutor that's also assigned to each particular circuit. There's 51 DAs for the state of Georgia. So you're talking about 51 different offices that have, these are the basic numbers that they have, of course. Then you have a drug prosecutor assigned to each circuit, and then you have an accountability court. If you have an accountability court in your circuit, you also have an assistant DA for that. And then finally, you have juvenile. If you do juvenile court, you have a juvenile assistant DA. So for my particular circuit, the South Georgia Circuit, which is made up of 5 counties, Mitchell, Baker, Decatur, Calhoun, and Grady, which is basically the southwest corridor of the state, a little over 90,000 people. My particular circuit, we have 7 assistant DAs, and of course I'm 8 as attorneys. Then you have 2 admin positions that are given to each particular circuit. And then you have 1 investigator that's given to each particular circuit. And then you have your victim advocate. Those are the positions that are given to every specific circuit around the state, okay? Then, of course, the counties can allocate whatever additional funds they have to give you additional positions. A lot of circuits, I think, do what I do too, is which we apply for federal funding. For instance, the VOCA grant, which is the Victims of Crime grant, and the VAWA grant, which is the Violence Against Women grant. And that, for my particular office, we use those to fund 1 additional admin, basically a paralegal, and then also a victim advocate that's funded through those particular federal funds.
Is a victim advocate an attorney position or not?
No, sir. The only attorneys I have are the actual prosecutors, the assistant DAs. The best way I can explain it, Senator Cowsert, and Mr. Chairman, is that basically the victim advocates help us manage the victims. I mean, I guess that's the best way to say it. So you've got, I think we average in my circuit 785 cases, somewhere around there for the year. A lot of those cases, other than drug cases, you're going to have victims in the case. You're going to have victims of crime, whether it's armed robbery, rape, child molestation. And so the victim advocate reaches out to them, and one of the key factors they have is there is some statutory things that we have to provide to every victim, the Victim Notification Act. And so that's what my victim advocates do a lot of time, spend a lot of time on, is making sure that we ensure what those particular provisions of that statute, making sure that all the victims know when court is, when victims have the right to know not only when court is, but also to have input. We don't necessarily have to to do what they want. But I think you're silly as a district attorney if you're ignoring the wishes of your victims in any particular case. That's one of the most important things I do. As I tell people, my number one job is to represent victims and victims of crime. And so we take that very seriously, and that's why I spend most of my federal funds that I'm able to procure, which is not a lot. I mean, we're talking a couple $100,000. That's primarily to make sure that we are ensuring that the victims are notified, they have their rights, and that everything is done copacetically through the court system.
And so statutorily, when you're talking about the Victim Notification Act, you're required to let the victims know when there's an arraignment date, when there's going to be a trial, obviously, and if there's a plea hearing and an agreement made. You reach out to them and make sure they are able to attend in case they need or want to participate in the process.
That's exactly right, sir.
And you also ask, not necessarily approval from them, but inform them of any plea deals that might be made so they can state their concerns if you're going soft on a criminal or something like that.
100%. One of the things that I do in my office actually is on our plea recommendation forms at the very top. There are 2 boxes. And again, I'm speaking solely as my practice, as my office. There's 51 DAs, but one of the things that I do on my plea recommendation forms is there's a box at the top that says victim has been notified, and that every ADA has to check that. Law enforcement has been notified of this recommendation. I think it's very important. Right. We send out all of the paperwork beforehand, and it basically gives them questionnaires. How has this impacted you? Is there any restitution? A lot of times you're going to have restitution in cases. We want to make sure we have all those numbers prior to grand jury. And again, this is my circuit. We have that prior to grand jury so that we can have that information in case the defendant wants to plead early. The more you get victims involved in the system early, in my experience in the last 22 years, it really does make a huge difference.
There is pending legislation in the Senate to add failure to comply with the victim rights laws, a subject matter or condition or something that would subject a prosecutor to discipline, potentially from removal from a case or other sanctions from the commission there. Are you okay with that, or how would you want us to word it? I have received feedback from other DAs is that sometimes it's difficult to do that if you lose contact with somebody or they don't tell you their current address. But I was thinking about wording it to say that you're required to take reasonable steps to comply with that. Is there a better way for me to phrase it? I don't want to put too onerous of a duty on a DA where they can be sanctioned for something that is not intentional or negligent misconduct, but this is of extreme importance to Georgians, as you've just mentioned.
Yeah, I'd be glad to look at it and discuss it with you after I'd had an opportunity to review that particular piece of legislation. But the idea and the premise behind it, I'm 100% in support of.
All right.
I think it's very important.
So what is the salary that the state pays per DA?
So it starts out, and it's basically a system that's based on years of experience.
Sure.
Starts out, I think, and you all have been so kind at the Capitol the last year to raise that salary. I think it starts around 72. And then it goes up incrementally about every year as long as you're doing all the duties that you're required to by law and practicing in the office in an efficient manner. I don't hold it to me, but about $2,500 or $3,000 every year, and it tops out somewhere around $135. So it's based on years of experience, and it's steps. You got step 1, class 1, and it goes down incrementally based on your years of experience.
Okay, so DA Willis is making $200,000 or more per year. I think she testified. Where's the difference come from between the state mandated pay and what she's receiving?
Sure. So I think the top pay scale, and one of the things that the payday bill that we have before the House right now at 1028 is that addresses it is the top pay scale for DAs currently, I think, is right at around 134 and change, it's somewhere around there. But if you look at the scale for the assistant DAs, I think it goes to around 135. And I'm paraphrasing my numbers as much as possible. I'm trying to be accurate, but if I'm off a little bit, that's about what it is.
Before you move past that,
Yes,
do you know where your assistant DAs start, if a DA starts at 72 or?
No, I'm
minimum?
sorry. The assistant DA starts at 72.
Okay,
The DA, actually, all the DAs, whether you're 1 year in or 22 years in, you're 134 and change, somewhere around
and
there.
they don't go up based on experience?
No, sir. No, sir. And I apologize if I didn't make that clear. That was ADA pay. Yes, sir.
All right, great. Okay, well, back to the 1028, that's a House bill.
Yeah, so the reason, one of the things that we need to clarify is because the DA has a set pay. Like I said, if it's your first term or your sixth term, like me or whatever, and it's 134, 7 something, somewhere around there. It's 134,000. But the assistant DA pay that starts at 72, it caps out at around 135,000, I think, it's somewhere around there. So you actually have 80-some assistant DAs, 3 in my office alone, that make more than I do. I mean, I'm lucky I've got some experienced DAs, but it's weird that, you know, the one that the chief elected officer is making less than a good bit of his attorneys. To answer your question, though, and I want to be concise, is that salary is based. Then the counties can give a supplement, currently under the current law, as much as they want. I know, yes, my salary, my supplement, and I do get a supplement. I've been the DA 22 years. I didn't get a supplement at first. I got one about after 15 years of being the DA, and it was $8,000. I think I got it up to 13 now after 22 years. I know that DA Boston testified yesterday, hers is like 92,000. So that's where that difference comes in the salary discrepancies between the DAs, is basically the county supplements.
Do you get any kind of longevity raise?
No, that supplement is the only thing I get. No, sir. I'm not even familiar with what that is, quite frankly.
Okay. All right,
Yeah, I figured, but yeah.
so all these other assistants, they're paid on basically a statutory scale, plus any supplements that the local government wanted to give?
That's exactly right. And I don't know that it's statutory. I think it's a prosecuting attorneys council's tiered system that we came up with PAC. Oh, it is in statute. Then it is in statute.
right.
Yes, sir.
So what happens when you have multiple counties like you do? Does each of the individual counties contribute to your supplement, or is this optional, or how do they work that?
So that's a great question. It's a cat fight. I mean, that's the best way I can describe it, is you've got to go to all 5 counties and try to get 5 counties to agree to this particular budget. And as y'all know, with the House and the Senate, it's hard. Imagine with 5 different counties. And in my circuit, you know, I've got Bainbridge, which is Decatur County, which we've got some pretty good industry. But then you've got Baker and Calhoun, which they got like 6,000 people, 12,000 people. They're tiny, and they barely keep the lights on in some of those counties. So the discrepancy between those counties, it's very difficult to get them to agree on my budget. My budget for my year is $238,000 for my 5 counties. That's it.
That's the supplement, that's the county portion.
That's the county portion, yeah. And
Yeah.
like I said, I get $13,000 from my supplement. Mainly that does is it pays literally to keep on the lights. It's my rent. It's my travel expenses to get to these 5 counties and travel with my assistant DAs and computers, equipment. And that's primarily what all that fund is.
So what is your total office budget on an annual basis for your circuit?
$238,000. That's it. I mean,
That doesn't include the salaries.
So yeah, well, it does, because I have one investigator in addition to my state ones. So the state pays for my 7 ADAs and the victim advocate, all those positions I said. I think it's like 13 people in my office. Basically, the state pays that.
So
that
do you
comes
have a
out-
budget that includes their salaries?
that is their salaries. That is the whole budget. That's my budget from PAC.
Well, it equals more than 238, or you wouldn't have but 2 people there, and you just listed 9.
No, what I'm saying is those are all my state positions. I call them my state positions because they're state funded.
So what is your total budget, state, federal, local, combined?
I could, is it all right if I ask Mr. Scanlon? Because
Yeah.
we don't, PAC pays all that.
Mr. Chairman, we can get you, and what DA Mulholland's trying to say is that you have a state appropriated positions. Almost all the PAC budget is state appropriated positions except for a little bit of travel. I can get you all those numbers for DA Mulholland circuit, and I can get you the numbers for any circuit you want and how those ADAs are paid. The $230-something thousand he's talking about is the county share that pays
I
directly
know what he's
to
saying.
him.
What I'm trying to find out is what's the total amount of money spent in the DA's office in his circuit?
In his
And that would
particular-
include the state funding, the federal funding, the local supplement. And I don't want to get my calculator out, but I've just been told how many assistant DAs and administrators and paralegals, et cetera. I'm curious how much money we're spending to
For the
fund
state
an
budget. I'll have that for you in
Not
5
just
minutes.
state, everything. I want to know how much money he writes out of his checking accounts every month, or that his
Okay,
people
he doesn't
get
write a
paid.
single check for the state appropriated people.
Okay.
That comes from PAC. We pay that directly to his state prosecutors, his state employees. The $230,000 is what he's cutting checks for. I can give
Okay.
you the amount of state funds that.
Per circuit.
Per circuit.
Okay.
And I will have that for his circuit in about 5 minutes.
Would you have the data on how much the county supplements, or
No, sir.
on the circuit basis? That comes from each DA.
That comes from each DA, and we do not know how much money each DA is supplemented, or what their ADAs are supplemented, or how much they're paid in the operations costs of the county.
So see, part of my concern, and it sounds like there's a House bill coming our way, is to make certain that we are compensating our district attorneys and their staff an amount sufficient to attract qualified counsel to prosecute. And I'm hearing or have heard that there are great discrepancies between circuits, that some more rural circuits or less wealthy circuits have extraordinarily smaller budgets or resources or numbers of prosecutors.
I think that's true.
And other counties are awash in cash and are very heavily supported by their local governments, and they might have, more attorneys even that are not state paid.
Oh, no,
if they're-
that is an absolute fact.
Yeah.
I mean,
And I'm trying to get a grip on that, to see, is there a discrepancy in the quality of prosecuting attorneys based on the wealthiness and the subsidies from various counties or circuits? And if the problem is, what if Joe can't get anybody to come work in Southwest Georgia because they don't want to work for $74,000 a year, and they can come to Atlanta and make 135 or whatever, pick a number. I want to make sure that we're offering enough to fill the positions that we're saying you should have, that the state will pay, and if not, to raise the pay. Okay, so I'm just trying to find the data and to get feedback. Mr. Mulholland's the big boss for the DAs. So I can just ask you, Joe, what do you think there's adequate resources for district attorneys' offices to pay your attorneys and your staff?
I don't. I think that I think it's a struggle. Now, last year when you all were, like I said, when you all gave us that bump to 72, it did make a big difference. I mean, I've seen the number of resumes that I receive probably increase threefold, just based
Good.
on that alone, which is great. Absolutely.
That's the mission. Great.
And Senator, you're 100% right. It is so difficult to fill our positions. I'm really lucky. And I take no credit for this. I think it's a culture issue that was developed over the last 20 years by my office as a whole. I've had 2 assistant DAs that would literally drive from Dothan, which is an hour and 15 minutes each way, that left that DA's office in Alabama to come to work in our office. I'm also the only, I think, DA's office in Southwest Georgia that's fully staffed.
Okay.
I mean, I know Doherty County, up in Doherty County, just north of us, Albany, I think they're half their office is staffed, and they have positions, they just can't fill them.
We had a major problem in Athens as well for a while, for a variety of reasons, but certainly money is one of them. And heck, I contributed to it. I stole one away. But they were all fleeing quick as they could from Deborah Gonzalez because they wanted to really prosecute, and she wasn't really prosecuting a lot of people. And I was able to hire a guy away, paid him $80,000. He had been making 70, and had experience and whatnot. And I know that's a problem. We poach them away from you into private practices that pay more, right about the time they get enough experience to be good.
You're 100% right. And it's not even just the ADAs. A lot of my secretaries, my legal secretaries, once they learn how to write an indictment and stuff, I've got the civil guys going over and getting them. I mean, it just is. You know, like you said, they get their teeth cut that first 3 or 4 years, and then they go out and they make the money.
Okay.
It's a problem.
So one of the thoughts that I have, and Senator Dolezal and I have been discussing in basically the code of conduct, so to speak, for prosecuting attorneys, we want some bright line rules what is or is not improper behavior, rather than just a vague appearance of impropriety. And so we're searching for guidance from you. I had a thought to sort of key in a general conformance with the Code of Professional Responsibility that's, developed by the state bar. And that would include an obligation for candor with the court, various other professional conduct, and zealous representation of your clients, et cetera. Is that too broad to incorporate that? I mean, that's so specific. Things that lawyers can get reprimanded or disbarred from if they're not a prosecutor. I think it may apply already to prosecutors that the state bar, is controlling that, but should we or should we not put that into code, that those type of violations could warrant sanctions of any type, including removal from a case,
I agree with you. I think that the model code for the professional responsibility already applies to prosecutors, and I think we're actually held to a higher standard in the sense that as prosecutors, if you look at those ethics and professionalism, we're here to seek justice, not necessarily to argue zealously for our client, which is what defense attorneys do. But I don't have any objection whatsoever to your idea, which is that there is a standard that's an inherent. And as a prosecutor, I think it's always good to have more guidance than less. So having something like that we can say, this is what the statute says is an impropriety, I think that's great.
I'm going to ask you to take a look at them, and Pete, if you would assist, kind of a homework assignment. That's a short fuse for you. Really like to know an answer next week. If there are any in particular, any specific ones that are so directed to a prosecutor that they need to be separately articulated in our code as requirements of a prosecutor, the failure to comply with could result in some type of sanction. I don't know if there's one on withholding evidence. If there's not, there ought to be, a prosecutor has an obligation to, not conceal evidence that's favorable to a defendant, et cetera. And that's more than likely in there, but if it's not, something like that. But if you would just sort of review, I could do it generically as a whole, or I could pick some of them that are particularly applicable to prosecutors. I almost prefer that route if you give me guidance. And Pete, if you would try to accumulate me some of the data on the overall budgets of each of the 51 circuits. If that's overwhelming, just give me a smattering of them, because I need to have a feel for the disparity, the range of resources available in different parts of the state for prosecuting attorneys.
Mr. Chairman, the only
Yes,
thing
sir.
I have are the state funds that we
Okay, but these people, all right, well then maybe I get that from Joe. Okay, Joe, did your organization keep that data for each circuit on what their, am I going to have 51 witnesses come in here and tell me what their budgets are?
Go ahead.
I can survey the DAs
Yeah.
and try and get that information. It would be voluntary.
Okay. You can tell the state funds anyway, the positions funded from the state, and the amounts. Local supplements, I'm going to have to get piecemeal. Your organization doesn't keep that?
No, sir. It'd be based on an individual basis. Now, I don't have a problem. I think Mr. Scandalakis was saying is we can send out a listserv to the email. We have a DA's listserv, in other words, that I could send that out and ask that the Oversight Commission's asking for that. I certainly.
That'd be helpful.
Sure, I'd be glad to.
Yeah, I don't know how much of what I'm hearing is rumors and how much is fact.
Sure.
And how much I'm maybe not remembering accurately. I have heard from somebody or another that Fulton County's is over 200 million. I mean, that's that didn't sound right to me, and I don't know who said that. I don't believe it was testimony in this committee. So I want to get some data, because DA Willis is in here complaining about being inadequately funded. Other DAs are coming in and saying, what's she whining about? I'd give an arm and a leg to take a fifth of that much budget, whatever it is. And I know there's disparities in pay rates in different communities as well. I'm trying to get a grip on it.
I'm
Okay.
more than happy to do that, sir.
All right. Thank you. If I could get Gary Bergman next. Gary, he's with Prosecuting Attorneys Council. You have a bit of expertise in forfeiture, and I am going to hand the gavel over to my vice chairman, Senator Dolezal, to question you. I unfortunately must excuse myself. And Bill, we'll get you next time when we come back. We are going to be meeting again next Friday. I'm not positive the time yet, but we'll wrap up with y'all. We're still trying to get some other witnesses as well. Apologize for me having to go.
You want to ask Harold if he's got any questions for
Oh, I'm sorry, Harold. Did you have questions? Yeah. Thank you.
DA gets 7 ADAs, is that right? Or paid by the state? How many do you get?
No, sir. Every district attorney, the formula for the state has.
Okay, that's what I was trying.
I don't think that might.
So the formula that the state has is you get one assistant DA
Per judge.
per Superior Court judge.
All right.
So there's I think 19 or 20 Superior Court judges in Fulton County, which means they get 19 assistant DAs plus the chief assistant plus the accountability court
Okay.
plus the drug court. So it's based upon the number of Superior Court judges you get. That's the formula the state
This is
follows.
for the state, okay, thank you.
Is there anything else, John? Maybe that'd be excused, Mr. Chairman.
Leader Jones, do you have anything else?
No, I don't have anything.
Yeah, you're good. Thank you.
Thank you all very
Thank you for being with us today. All right, Mr. Bergman.
Yes.
Thank you for being with us. Can you just give us a little bit of your background, tell us what you do, and then we've got a couple, I'd like to get into discussion
Sure.
on forfeiture funds.
My name is Gary Bergman. I've been an employee of the Prosecuting Attorneys Council for 35 years. In that time, I've done asset forfeiture work for the entire 35 years. I used to actually prosecute forfeiture cases, but I haven't done that since about 2009, 2010. Now I just teach asset forfeiture to law enforcement and prosecutors. Between 2011 and 2015, the legislature passed the Uniform Civil Forfeiture Procedure Act. I worked with Chairman Wendell Willard on a study committee for 4 years and helped shepherd that bill, which was House Bill 233, into legislation. And it was passed in 2015. And as I said, I helped write it. And part of that is, I think what you're interested in is the use of forfeiture funds by DAs. And there is a particular statute that limits what a DA can use forfeiture money for.
Walk me through the allowed uses under, that was the 2015 Act.
That would be
That's the
9.
current state of law. It was still the 2015 Act. Has it been unchanged as it relates to uses since then?
Well, the statute, the actual provision that you're looking for would be 916.19A as an apple 5, which is official prosecutorial purposes. And it lists certain categories that a DA can use their forfeited funds for. For example, trials, appeals, forensic services, investigations, victim witness. Those are just to name a few.
And I assume as a non-attorney, which I am a non-attorney, that the reason for that is that you're trying not to create essentially an incentive for prosecutors to seize assets and then be able to use them kind of at their discretion outside the uses listed
That would
there.
be,
Is that-
in my opinion, that would be unethical. But DAs don't seize property.
Sure, I would say, call it the law enforcement.
Right,
the-
and DAs, I
industry
think,
as a whole.
have to be a brake and a check on law enforcement seizing assets. And it's the DA that has to look at this and say, I see that you seized this, you may have had probable cause to seize this, but there's not enough for me to prove the case by a preponderance of the evidence, and therefore we're going to need to give the money back, or the car, or whatever property.
One thing that we heard in testimony from, or one thing we discussed with DA Willis was essentially that there's a smaller number typically of federal forfeiture funds that are distributed, it sounded like, based on her testimony, equally around the state or the country, and then there's obviously your local forfeiture funds.
I have no idea about federal forfeiture funds.
You have no idea about what?
About federal forfeiture funds.
Okay. Meaning you don't know if they exist, or you just don't
Oh, no,
know
I
of
know
the,
they
of the
exist.
uses or
What I know about federal forfeiture funds is this. They have a program called equitable sharing. So if the feds, and I call them the feds, the U.S. Attorney's Office, if they forfeit property through the federal government, federal law, they will share, I think it's 20% of that money with locals if they were involved, okay? And you have to apply, and then you get this equitable sharing, and it's almost always cash, money. It's not really property or anything else. And in 2015, when we passed the Uniform Civil Forfeiture Procedure Act, the state required that DAs, if they receive this type of federal property, through equitable sharing, that they have to report it on their annual state report, which wasn't required before.
Do you know if the allowed uses are identical between the two sources of funds, or do you know if there's any different allowed uses between state and federal forfeiture funds?
So there's a definite overlap, but there is a guide for the feds, a whole book on equitable sharing. And I can tell you that my opinion is that in 2014, when the Uniform Civil Forfeiture Procedure Act, or I'll just call it the Procedure Act, was passed, the legislature came to the sheriffs and the DAs and said, we need some guidance. We need some, parameters as to what you can use it for and what you can't use it for. Tell us what you want, and we'll look at it and we'll make a decision about whether we want to legislate that. And I know that the law enforcement, I think, went to the equitable sharing guidelines that existed and pretty much copied a lot of them and said, these are the parameters that we want to be able to use it for. And I think to some extent the DAs took some of that and put that in theirs. But primarily law enforcement, not the DAs. The DAs came up, I think, with their own list. And again, that's in 91619 A5. But there is some overlap. Now, that was in 2015, and they used the books for equitable guidance that were like 2006, 2008, and they were still, the feds have since amended their books. It's still very much, pretty much the same, but it's not completely the same as what it was in 2006 and 2008.
What are the reporting requirements at the state level?
What are the requirements?
The reporting requirements.
Oh, okay. So the reporting requirements are again, still found in 91619. And they basically require the state or the law enforcement and the DAs to report what they received during the calendar year. Okay? So they don't report what is seized. Okay? Because everything that is seized is going to get reported either as forfeited property or returned. Okay? And if it's returned, they still have to report that. So it'd be a duplication of effort. So if it's money, and I'll just take the DAs, for example, okay? The DAs, they only get 10% of the forfeiture if they want it. Not every DA wants it. But if they do, they generally get 10%. They would report what they got. So if it was let's just say a forfeiture of, and I make this very simple, $10,000. The DA would get 10%. It would be $1,000. They would report that they received $1,000. And what I tell them is, when you take that, when you receive that money and you put it in the bank, that's the date you received it, okay? And this would continue, okay? I got $5,000. I got $3,000. So they would report every time they received money, okay? Now, they would also report every expenditure of forfeited funds. So if you received, over the course of the year, and again, very simple, I received $50,000 over the course of the year. In December, I bought a car for $40,000. You would report that, the make, model, and you would report how much you paid for that car. And then the report will, our reports aggregate the amounts. So this is how much I received during the year. This is how much I expended during the year, okay? And then at the end of the year, excuse me, the statute requires that you report what they call cash on hand. And that simply means I started with X amount of money, because nobody starts at zero, and then what you do is you have a specific fund called a forfeited funds account, all right? And you've put money in it, you've taken money out of it. At the end of the year, like December 31st, what I tell DAs and law enforcement is, you take a look at you go look at your bank account. Whatever that number says, you report that number. Because
Do they report the federal expenditures to you?
They do.
Okay.
Now, they didn't used to, like I said, since 2015 they have, July 1st.
Are those funds typically commingled into one account by most DAs?
No. I tell them no, they should not be. Because the feds have their own reporting requirements, and the states have their own reporting requirements. They're not the same. Ours is a calendar year. I think theirs might be a fiscal year.
You say you tell them not to. Is there a rule or a part of the statute that tells
Our
them not
statute does not have that.
to? So the statute is silent on the commingling of funds. You're
About
just
commingling
advising
of
them on a
funds.
best practice.
Yes, because otherwise, how are you going to know when you report at the end of the year how much money is actually forfeited from the feds, and how much money is state forfeiture, and how much money is if you're putting operating expenses in there?
Do you know if the federal law is silent on the
I
commingling
know
of funds?
nothing about federal
Okay.
law.
Part of the work, and really the primary work of this committee, is to make recommendations for changes to state law.
Okay.
Do you believe that the law needs clarity on the commingling of funds? You think it's a best practice, it's not in the code. Do you think it should be in the code?
And that's a policy decision, honestly. I can't see why it
Do you
would.
know of any DAs that are, or have you heard of DAs that are commingling funds?
No.
Okay.
No. I have heard that some DAs may use their county to hold their funds, and I don't, I assume that the county doesn't do that. But, this is all about accounting and auditing, because what I tell any DA or any law enforcement officer is that you want to keep very good records, because, you have to report all these things. And if somebody comes back and questions what you've done and says, I want to audit your account, you have to keep good records, and you should keep separate accounts. Now, as to seize funds, there is a specific part of the statute at 91610C as in cat that requires that seized funds have to be placed in an account separate and apart from all other accounts. So there is a non-commingling aspect as to that. But I don't believe that there is a non-commingling statute as to forfeited funds. And
You
what-
referenced on the usage, and I tried to write it down as quickly as you were saying it, trials, appeals, evidence, I think you said, and then I couldn't keep up.
Oh, that's all right. They're listed in 916, 19.
What about personnel?
You can use your money to pay state benefits and salaries. But
What about contractors?
you can pay contractors, but you have to pay them on the state scale. The statute requires that. So in other words, the DA hires me. I'm retired. I'm not retired, Pete. I'm retired in place. And they want to hire me, okay? But I don't want to be an ADA. But they said, well, you know, we'll hire you as a contractor. Well, they have to pay me like on a state scale. So they would look at my experience, you know, and then they would just about place me on that step increase or whatever, place me, and then they would pay me according to that. So they would treat me exactly as if I was a state-paid assistant district attorney. In other words, if I was out in private practice and I was charging $200 an hour, and I said, you know, you want to hire me, you would have to hire me at $200 an hour as a contract. You can't use forfeited funds to do that.
Well, that's exactly what Fonnie Willis did. So walk me through that, because Mr. Wade was paid 200 and something, I forget the exact amount of per hour that he was paid. He was a special assistant DA. Not only Nathan Wade, but on that particular case, there were a number of, Ms. Cross, I believe, and there was another gentleman who was paid that were all in that same scenario. Are you saying that if she obviously could do that, but with her budgeted funds, but if that was done with forfeiture funds, then you're saying that would be a violation of this act?
In my opinion, yes, because the statute requires, again, it's in the statute. I wrote a memo to Pete in 2021 on the use of forfeited funds to pay salaries and benefits. I have a copy of it here, and I would be happy to share that with the committee.
If you could get a copy of that to the committee, that would be great.
I'm
What are
happy to.
what are the remedies, if any, that exist for a violation of what we just talked about?
Okay, so are we talking about DAs or law enforcement?
Let's talk about DAs.
Okay, so if a DA makes a report, all those reports have to be submitted to the PAC. Now, you know, we don't really look at them honestly, but that they're also reported yearly to the state auditor. If the state auditor looks at it and finds a problem, they will go back to the DA according to the statutory scheme and say, here's my problem, you need to fix this. You know, and if the DA refuses, and part of that might be that the DA has to pay back the money because they used it improperly. Okay. If the DA does not do that, then the state auditor reports that to the Attorney General, and then the Attorney General can take whatever action, civil or criminal, against the DA for misuse of forfeited funds.
Are there any remedies if is the only remedy the state auditor catching that, or is there a remedy if the state auditor, I would assume these reports are public, are they subject to open records requests?
All reports are open.
So if I went and pulled a report and I saw a violation that was missed by the state auditor, what is the process for?
I assume that you could go
remedy?
straight to the Attorney General and point that out. You don't have to go through the auditor. The statute just requires that if the reports go to the auditor. If the auditor sees a problem, it goes back to the DA. If there's a problem there, and the DA and the state auditor thinks that the DA is not fully compliant with what the auditor thinks should have been done, then the auditor goes to the Attorney General.
Ms. Willis testified that she was unaware as to how Mr. Wade was being paid and what the sources of funds were. She testified that she never reviewed his bills. She testified that the payment vouchers that we showed her on the screen She had never seen those before. They were signed by someone else on her staff. And that very clearly indicated separate funds. There was I believe it's Fund 100, it's on my computer, but there's Fund 100 from Fulton County, which is the general fund. Some of Mr. Wade's bills were paid out of Fund 100. And then there was Fund 400 and something, if my memory serves correct, that are the forfeiture funds. Would that be visible on the report that you're saying goes to the state auditor? Obviously, if it's a forfeiture fund, it would have to be reported, but it's reported in a bucket. I guess what I'm getting at is, how specific is the report? Would that just say trial work? Would that say
It would
investigatory
just say
work?
trial, it would say trial work, investigations, or something along those
So
lines.
there may not be a way for the state auditor to see.
No, the state auditor would
that-
have to look at it and think that there was a problem.
Yeah,
Or just have an audit
So
for
again,
forfeited funds.
I'm sorry. We'll let you catch up. You tell us when you're ready.
You said the auditor would have to look and see if there was a problem.
Yeah, I can't hear you very well.
She said that you can go back to the podium. Go back to the podium so you can be in the microphone if you don't mind.
I don't mind.
She said that you're saying the state auditor would have to look, and I'll let you restate what you were saying so she can capture it.
The statutory scheme is that the reports by the DAs go to the state auditor. The state auditor would look at the report. If the state auditor sees that there is a problem, the state auditor would go back to the DA and say, here are my problems with your report. It would then be up to the DA to make those corrections that the state auditor is requiring. If the DA does not do that, and part of that could be pay back the money, then the state auditor takes findings to the Attorney General, and then the Attorney General has the authority to take whatever civil or criminal action it deems appropriate to force the DA to comply with the statutory requirements of the statute. Is that clear enough?
You got it. You're good. Sorry about that.
I speak fast, I'm sorry.
And then you and I both, and then we both talked over each other, so my mistake.
I'm sorry.
Okay, so I just want to clarify the state pay scale piece that you're talking about, as it references essentially the hiring of outside contractors. That is in the 2015 Act. That's part of this 91619 somewhere in there. We
Yes,
can go find that.
it specifically references two statutes. One is state-paid employees, and the other one is something called spacers, state-paid, county reimbursed. In other words, the county pays the state pays for a particular ADA, and then the county reimburses the state that money. So it's really county, they're county paid, but they're state paid. So
Are there any other restrictions on the use of, or the hiring of personnel? Any certain areas they can't work in, any certain areas they're required to work in? Is there any general provisions around personnel that we should be aware of?
in the statute, no. There is a statute in the criminal law, so Title 16, that prevents contingency fees, I think, for forfeiture work. But the statute itself, the forfeiture statute, would prevent, say, contingency fees. It would prevent signing bonuses. It would prevent incentive pay, okay? And then, as I teach it, it would be an appearance of impropriety if a DA used a contract prosecutor to do forfeiture work, okay? Because then it seems to suggest that the DA, that this contract prosecutor is getting paid through forfeiture money.
Sure.
That would be certainly a conflict of interest.
One
So-
thing that caught our attention and the attention of a lot of people around the country were the billing practices of Mr. Wade. They were unique. They certainly differed from the other individuals who were also billing for the case. And what made them unique was they were all in the even hour rounding number. They were often very short on detail, and they were almost exclusively 8 hours of what we've referred to, at least colloquially in this committee, as block billing. Is there anything, either in the act or more broadly, that you can speak to that would address any of that? There is concern that lack of specificity and as it relates to the use of taxpayer funds may be something that we need to look at as a legislative recommendation. Is there anything that you're aware of anywhere, either in bar guidance or the act that you're talking about, or anywhere else that would speak to that?
Not that I'm familiar with. Now, again, the code section says you have to pay somebody according to the state paid schedule, okay? So as a state paid. And I will give you an example, okay? Open records, okay? We have to, when you do an open records, and I do open records too, besides asset forfeiture. Pete loves me. When you bill, okay, you pay the lowest paid full-time employee that in the discretion of the executive officer is capable of doing the work. So if that happens to be a lawyer in the office, okay, as the lowest paid full-time employee capable of doing the work, then you would take that person's hourly wage. So I know how much I make, and I can just tell you that I make, and on an hourly basis, I make $64.83 an hour. And if I'm billing it, I bill it out at $64.83 an hour. So and I'm at the top of the pay scale, okay?
Yeah, so let's talk about that for a second, because this kind of ties in with the last testimony. You're in the range of the 138,000. Is what it sounds like, because I'm just doing 138, which I believe, Pete, you said or somebody said was the top of the range for the...
Right, I don't get that.
Okay. But that is the top of the range. Divide that by 2,000, you're at $69 an hour. In the billing and the use of forfeiture funds, because that's not the full comp plan for a person making 138. They're making 138, there's FICA contributions that happen, there's other things, obviously there's full benefits package. Is the DA able to consider a benefits package as it relates to calculating what they're able to pay an outside contractor to bring them in to do the same work?
Not that I know of, but...
So it is straight salary divided by calculating an hourly rate. You cannot consider benefits or anything like that?
I do not believe so.
Okay.
Again, I'm not a finance guy. I know what the two statutes say, and as far as I'm concerned, and not being a finance guy, and not knowing those statutes as well, like I would. I mean, it just, as far as I'm concerned, it requires that you pay them on the same scale you would pay a state-paid employee.
Okay.
Mr. Chairman,
Sure. I'll turn your mic off so it doesn't get... Let me turn your mic back on. I want you all to be able to... Go ahead.
I'm talking about state funds, paying
Correct.
state funds. Again, if you're talking about a county, the county can pay a contract
Correct.
employer as much as they want to pay them.
Correct. And I think that's where the question came up for the committee, just because in this particular instance of what we're looking into, at least according to Fulton County's payment vouchers, there were different sources of funds that were used, and one of those sources of funds were the forfeiture funds. Leader Jones, I saw you taking some notes over there. Do you have any questions?
Chair.
Yes.
It's kind of like on the same line. So there is no rule against being able to pay with the forfeiture funds and then also with budgeted funds. If you were paying me as a contractor, you could pay me for forfeiture funds and then also with budgeted funds. Would that be permissible?
I guess.
Okay.
Yeah.
And then the second one is on the hourly rate, and we're talking about, let's just, whatever it may be, $69 an hour, whatever it is, would the person be stuck at, if you're paying me as a contractor hourly rate, would I be stuck at only being able to bill 7.5 hours a day or 8 hours a day, or could I go beyond that? Because a normal state employee is only going to be working 7.5.
You can't make more than the yearly rate.
I got you. Okay, I see.
Okay, I mean,
Right.
again, that's a salary, I believe.
Right. Even, I understand what you're saying. I got you.
Okay, but if you
Interesting.
were
So
to pay
there's-
more than, if you could pay it more, it would still be if you're me, $64.83. I work 8 hours times $64.83.
Right.
You're not paying anybody $200 an hour, $100 an hour, $500 an hour,
You good?
Any other questions?
Not for me.
Leader does not have any more questions. I just want to clarify what I just heard, and perhaps this will help our reporter as well. You're saying essentially there's two ceilings. There's an hourly ceiling, and then there's an annual ceiling. Did I catch that correctly?
What I understand is that you have to pay according to the salary schedules. I don't know, and nobody's ever asked me about whether or not you can go over that amount. In other words, I work. I'm a contract employee. I'm working 80 hours a week on a case, and I've been working for 10 months. That's going to put my salary above the
I understand the math
the
on
yearly
that. Are you
salary.
saying that's problematic? Or
I think that is problematic.
Okay. So
But
there are-
I'm
you're-
not sure whether the statute allows it or not. I'm sorry, I'm talking over you, but I'm
No, you're
trying
fine.
to answer your question.
If you don't know whether the statute allows it or not, why is it problematic?
I've never seen that, nobody's ever asked me that question before. And I don't know. I don't know enough about those two payment salary,
I gotcha.
those two statutes, to know whether that's problematic. Personally, I think that could be problematic. Is that better?
That's, yes. Yes. And I think that as it relates to this particular instance, either or were exceeded in this case.
Right.
We'll look at the language of the law, at the plain language of the law, and obviously we can bring recommendations back to the committee. I want to thank you all for being here today. Leader, did you have anything that you had thought of? Okay. Thank you all for being here with us today, and did you get everything you needed? Okay, fantastic.
Just to be clear, I also have something called the Best Practices Guidebook for Use of Asset Forfeiture Money, which the DA's Association wrote in 2015 when the Uniform Civil Forfeiture Practice Procedure Act was passed. If you would like, I will send that to the committee.
That would be
as well.
fantastic if you could send that to the committee.
Okay.
Gentlemen, thank you both for being here. Bill Finch, if you're watching this on your way home, is my solicitor. Sorry we didn't get to you. We'll get to you next Friday, and this committee hearing is adjourned.